It's a brave new world. And Mr. Johnson, when I was starting out as a new lawyer 20 years ago, I would run into um, Miss Rockwell uh, on those calendar calls, those cattle calls in Fulton County, um, quite often. Okay, today is April 8th, 2022. This is the bond hearing calendar. My name is Brad Gardner. I'm going to be presiding over this calendar. We have one case, State of Georgia versus, is it Schuler or Schuyler? Schuyler Calhoun. And he is present. He's represented by Ms. Renee Rockwell, and Mr. Sean Johnson is here on behalf of the state. And this is Ms. Rockwell's motion, so she gets to go first. Go ahead.
Thank you, Judge. Judge, for the record, you can see that Mr. Calhoun is actually out on bond.
Yes.
This was a consent bond by ADA Cheryl Freeman.
Mm-hmm.
And the bond judge had various conditions. Number one, upon his release, she wanted him, Mr. Calhoun, to immediately have a mental health evaluation. The facts of the case, and I will tell you that to give you a bit of history, and may I state in my place, or I can have Mr. Calhoun placed under oath just to tell you regarding a very bad motorcycle accident.
No, you can stay to your place.
Okay, he was involved in a very, very bad motorcycle accident and was consequently undergoing after the accident surgeries. He sustained a compound fracture and was prescribed some medication, and by all accounts was taking the medication as prescribed, but was involved in an incident where he was not eating at all, was taking the medication. The medication, he had a reaction to the medication, totally blacked out, has no recollection of what happened, was involved in an incident wherein his wife and children were in a car, and there was a car crash. It wasn't a bad crash. What was bad was that Mr. Calhoun had no recollection of it, was very, very confused. The officer so stated in the police report that he was talking about Jesus and seeing the light, and nobody can take him away from keep him from Jesus. And he was pulling his wife out of the car. And the bottom line, Judge, it was he had a string of charges, sat in jail, was initially the comment in the police report, the officers saw that he was very confused and so mentioned it. Initially in jail, he compensated. He came back, and Ms. Freeman did not want him to get out without some type of I guess you would call it evaluation. He did see Dr. Mall. Dr. Mall did, and I shared the evaluation with Ms. Freeman. What I will tell you, Judge, that in speaking with Ms. Freeman and also with ADA Johnston, the state is not going to consent to the contact, to us changing the contact, but I think the state would state in its place that perhaps they've spoken with the victim, and the victim does want to have contact with her husband.
You do say does want to have contact?
Yes, okay, sir, and I'll ask her or I'll ask the state to state that or confirm that the medical or the evaluation did by all accounts prove that Mr. Calhoun or the opinion of the doctor was that Mr. Calhoun was non-compliant at that time with his pain medication, albeit not taking it with food. I don't know if he took too much. Whatever happened, it confused him. What I can tell you is that he is not on any pain medication now. He is gainfully employed. He is living at his mother's home. That's another thing. Miss Freeman obviously did not want him to go back home. The evaluation did speak of and suggest that there was family counseling, obviously, so that everybody could get back in place. I know that the children want to see their father and have contact with their father. And obviously, Judge, whatever the court feels safe with, in other words, a step up type of reconnection if the court feels more comfortable. But all in all, he is gainfully employed. He works at the Crown. I'm sorry, what is the name of the hotel? Mr. Crown Plaza in Midtown. A good friend of mine used to work there, Judge, a long time ago. I will tell you about him. You'd remember him. He was a security guard there. Mr. Calhoun is about to get even a bigger promotion. He is a chef by trade. He is the lead cook. He is in charge of the kitchen when he is on staff. He is in charge of the banquets for the hotel and is about to be the head banquet coordinator. He is just under the sous chef, and he has also promised me that he's going to cook me a meal at some point when he's not juggling all that. I think that perhaps I would like to proceed. I know the state doesn't necessarily want to call the victim, but if the court wants to hear from the state regarding the victim's wishes about reconnecting, obviously it would be no further violent contact with the wife and the children. Mr. Calhoun is without record. He is 33 years of age. He is from Atlanta. He has 4 children with the victim, and also is the father figure to the victim's biological child. The victim's biological child is 17 years old. When I say victim, I'm talking about his wife.
I understand.
And they have 5. The biological child all the way down to a 3-year-old. So there's 5 total. And I know that Miss Hurt was planning on taking them all to Florida for spring break, but did not want to cancel the trip. Not with Mr. Calhoun, obviously.
I understand.
But canceled the trip because it was important for her to be present today. And obviously we're here on a Zoom here. And so she might have been able to go to Florida with her children. But if the court wants to either hear from the state regarding what the victim's wishes are, I can tell you that there is no need per the mental health evaluation for any kind of prescription medication as
now,
far as
Miss Rockwell, I want to remind you, you have another court appearance.
Okay. And
Can I ask a question of the state? Is there anything that Ms. Rockwell stated that you disagree with?
I don't believe so, Your Honor. The state is opposing there being the bond shifting from contact to no contact, and I can further elaborate the state's position when the court wishes me to do so.
Let me hear from the state as to why they're opposing.
Yes, sir. So in this case, the defendant warrants were taken out, and the defendant is facing charges for 6 counts of aggravated assault. That is 2 counts of aggravated assault against his wife, Miss Brittany Hurt, who is on the Zoom call today. And then there's 1 count of aggravated assault for each of the 5 children that were in the vehicle when the crash occurred. And there are 5 counts of cruelty to children in the first degree, again, 1 for each child that was in the car, and 1 count of simple battery for the attack on his wife. Your Honor, just a brief proffer of the facts, just to make sure that Your Honor is clear on what happened.
Hold on, Mr. Johnson. Hold on 1 second. Let me ask you a question that may prevent you from having to go through all of this, the recitation of the facts. Is it the state's intention to continue the prosecution of Mr. Calhoun?
Yes, Your Honor.
Okay. Ms. Rockwell, if that is going to be the state's intention, I'm not going to change the condition because I would essentially be putting a witness with a person that is going to be prosecuted by the state.
I understand, Judge. I just didn't, prior to him being convicted, I just didn't want the family to be in any kind of predicament where, obviously, I don't know what the state's position is regarding his capacity at that time. He remembers nothing. It was a situation where at some point with the facts as stated by the state and our position, obviously the defense is going to have a motion at the time about any kind of criminal responsibility at the time of the event. But at this point, I know that the children, and I'm not asking that he move back in, Judge. I just want there to be some type of contact with his family. And I don't know when the I do
when
know
the case will go to trial. You don't know how long it's going to be. And I do understand that, and I'm sensitive to that. The number one thing that I'm looking at is the idea that Mr. Calhoun, if this case is moving forward, would not be allowed to have contact and interactions with potential witnesses. Now, he's an adult, his wife is an adult. What they choose to do is what they choose to do. I understand that there are conditions that are in place, but I would not feel comfortable modifying this condition such that, what are you going to testify about tomorrow? Hey, son, daughter, you don't want dad to go to prison, do you? And I don't know where this case is going to be. I don't know to the extent that the state intends to prosecute, where it appears that they're going to have maybe witness problems. That's a decision the state gets to make. But I want to keep the bright lines in place while this case is making its way through the judicial system.
I understand, Judge, and I'm in connection with ADA Freeman, who is she's on top of everything regarding the mental health evaluation. I know that the doctor that he evaluated with is in charge of his Family 360,
Hmm.
um, who thinks that there needs to be some counseling
Hmm.
with group counseling. That's going to be difficult with a no contact clause.
Right.
Um, and I know Miss Freeman is out, and I just don't want to set him up for any type of failure.
I
I
understand.
don't want this to be a complete division in the family. Um, the children will, eventually. I mean, at some point, I don't want this to be a 4-year deal. We don't know how long before we're back in court. Um, what I may do is I would like to revisit this without being prevented. Not that the court would prevent me. You know what I'm saying. Just to
Exactly.
revisit this sooner rather than later. Even if we can first start out with the doctor, the counseling, with Zoom sessions, group counseling with the family and the wife. And I will just ask Miss Hurt if possible, if she can just unmute her phone or turn on her camera, just so we can have it down on the record when ADA Freeman gets back, so that I can just memorialize her position as far as contact and trying to put the family back together.
Okay. Ms. Hurt, would you unmute yourself and turn on your camera?
Yes. Trying to turn on my camera now. Hold on one second. Hello, Judge.
Okay. I'm going to, it looks like you have changed devices. Is that correct?
Can you hear me?
I can hear you. It looks like you have changed devices. Is that correct?
No, I haven't changed devices. I just had to go to my settings.
Okay. Would you raise your right hand for me, please, ma'am? Do you swear affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Have you been listening and paying attention?
I'm sorry, Judge. What was that?
Have you been listening and paying attention?
Yes, sir.
Do you understand that the representation made by Ms. Rockwell, you can put your hand down, ma'am, I'm sorry. That the representation made by Ms. Rockwell is that you would like this bond condition to be removed or modified so that your husband can come back into the home.
Yes, and I totally agree.
Do you understand that at this point, I am not going to remove that condition?
I do understand.
Ms. Rockwell, I am totally okay with revisiting this issue. I do believe that families should be together, but I also believe that that there can at times be situations where families shouldn't be together. And unless and until I am satisfied with that, I'm going to keep this condition in place.
I understand.
So I know Ms. Freeman is very diligent. Mr. Johnson, this is my first time interacting with you. But as long as there are concerns or issues in place, as a judge, my concern is for everybody's constitutional rights and safety. So that's the reason I'm making that decision today, Ms. Hurt. But Ms. Rockwell is a very good lawyer. She has committed that she's going to continue to try to work with this issue. And I'm committing that if there's a point that this needs to be revisited, I'll happily revisit it.
And Judge, just for the record, I did want that memorialized, so ADA Johnson could do that with Ms. Freeman. And Ms. Hurt, you can mute your microphone if you want to. I know you got a lot going on. Good for you with the children. Judge, and just for the record, just so Mr. Calhoun knows, my next move for the state and for Ms. Hurt and for ADA Freeman and the court is I'm going to try to share with Ms. Freeman a way that, because Families 360 and Dr. Mall does suggest the family counseling, if we could crawl before we walk and run and soar, just try to set up maybe some counseling sessions via Zoom with the entire family, just to try to put it back together. I don't want to have to wait 90 days or a change of conditions and all that. So I thank Your Honor for allowing me to revisit it. And I just know that at some point I'd like to come to the court with a consent order. And I can assure Ms. Hurt and my client and the court that Ms. Freeman does have her hands on the wheel.
Right.
And she's at some point, I think she'll be comfortable with it. Like I said, we're going to crawl before we walk or run. And that is my plan with counseling sessions, even if it just starts out via Zoom. I mean, if I had my choice, I'd turn back the hands of time and this would have never happened in the first place. But we know how that goes. So thank you, Judge, for providing this. And I understand the court's position. I even told Mr. Calhoun that until we have the state 100% on board, it may just be it may be something that we have to work towards. But thank you, Judge, and may I be excused?
You may be excused, and just so you know, I would have no objections to modifying their contact so that there is counseling sessions by Zoom.
Okay. Let me do this.
But
then.
speak with Ms. Freeman first about that.
I'll speak with her just to tell her about the platform and all of that. Because everybody counseling doesn't hurt anybody. So and that's the goal, Judge, to put it back together within the comfort zones of the state and the court. So
Okay.
I'll do that and I'll get with Ms. Freeman. And thank you so much, Judge.